This is Shenna speaking. All right, the time is now 2:01, and I am hopeful that you all have come into the space and gotten settled. Welcome to the webinar on rural rental housing options for survivors. Thank you for joining us today. My name is Shenna Morris, and I identify as Black and use she, her pronouns. I am the Vice President of Policy and Systems Change at the National Resource Center on Domestic Violence, or what may be known as NRCDV. I'll share more with you about NRCDV in a moment, as well as welcome my co-presenter, Natalie Maxwell, to introduce herself and talk more about her organization, the National Housing Law Project, or NHLP. I am wearing a light brown shirt with floral print. I am wearing glasses and also have my hair pulled back in a ponytail to provide a bit of a description of myself today. Today's webinar is being recorded, and with that, I'll hand it over to our interpreters now to provide further instruction on language interpretation that will be provided during today's webinar.
Thank you so much. Muchas gracias. Hola, buenas tardes. Yo me llamo Talis. Estoy aquí con mi cointérprete Allison y vamos a ser sus intérpretes del inglés al español durante este webinario. Hi, good afternoon, everyone. My name is Talis. I'm here with my co-interpreter Allison, and we will be your Spanish-English interpreters during this webinar. Venimos representando a la cooperativa de lenguaje Tilde. Y para acceder a la interpretación al español, si prefieren escuchar este webinario en español, si están aquí a través de una computadora, deben estar viendo un globito en la parte inferior en medio que dice interpretación. Pueden hacer clic ahí y ahí van a poder seleccionar el canal de español. Si son bilingües o prefieren escuchar en inglés, no necesitan hacer nada, pero si prefieren escuchar en español, por favor, adelante y seleccionen el canal de español. Si están aquí a través de un teléfono inteligente, hay 3 puntitos en la parte inferior derecha que dicen más. Pueden hacer clic ahí, seleccionar interpretación de idiomas y de nuevo van a poder seleccionar el canal de español. Al igual si están aquí a través de una tableta, también van a poder ver esos 3 puntitos. So to access a Spanish-English interpretation during this call, for people that would like to listen and participate in English, you should be seeing a little globe at the bottom center of your Zoom screen if you're here via a computer. It says interpretation. You can click that, and there you'll be able to select the English channel. If you're here via a smartphone or a tablet, there should be 3 little dots at the bottom right corner that say more. You can click that, and once again, you'll be able to select interpretation and then the English channel. If you are bilingual in English and Spanish, you don't need to select a channel, but if you're not bilingual, please go ahead and select the English channel. Por favor, les pedimos si hay cualquier problema con la interpretación que nos hagan saber a través del chat y les ayudaremos en cuanto podamos. If there are any issues with the Spanish interpretation, please let us know through the chat and we will help you out as soon as we can. We also welcome our ASL interpreters into the space. También le damos la bienvenida a los intérpretes de lenguaje de señas americano. Muchísimas gracias. Thank you so much. Back to you, Shenna.
Thank you so much. This is Shenna speaking. And thank you all for introducing yourselves in the chat. It looks like we have a great audience today from various different types of organizations, as well as backgrounds. So excited to dive into today's content with you all. So again, my name is Shenna Morris. I'm with the National Resource Center on Domestic Violence. NRCDV, as you can see from our slide here, provides a wide range of free, comprehensive, and individualized technical assistance, training, and specialized resource materials. Our mission is to strengthen and transform efforts to end domestic violence. Next slide, please. NRCDV is one of several collaborative partners who partners and provides training and technical assistance under the Safe Housing Partnership Technical Assistance Consortium. We like to call it SHIP-TAC. SHIP-TAC is inclusive of leadership and collaboration with federal partners from the Office on Family Violence Prevention Services, or HHS, the Office of Special Needs Assistance Programs, that is under the Department of Housing and Urban Development, the Office for Victims of Crime through the Department of Justice, and the Office on Violence Against Women, which is also under the Department of Justice, as well as the U.S. Interagency Council on Homelessness. Next slide, please. This collaboration is also inclusive of training and technical assistance providers who you will see here. Those providers are Collaborative Solutions, the Corporation for Supportive Housing, the National Network to End Domestic Violence, the National Resource Center on Domestic Violence, the National Sexual Violence Resource Center, Safe Housing Alliance, and the Safety Training, Technical Assistance, Resources, and Support Indigenous Safe Housing Center. Again, these organizations all work together to provide training and technical assistance that is responsive to meeting the housing needs of communities, the programs that serve survivors, and survivors themselves. And so with that, if we could go to the next slide, I'll give space for my co-presenter, Natalie Maxwell, to introduce herself.
Thanks, Shenna. My name is Natalie Maxwell. I'm the managing attorney at the National Housing Law Project, or NHLP. I use she, her pronouns. I'm a Black woman, and I have shoulder length Black hair that's twisted. And I'm wearing a floral top and a Black jacket. And I'm happy to be joining you all today. NHLP's mission is to advance housing justice for underserved people and communities. For over 10 years, we have been funded by the Department of Justice's Office on Violence Against Women to serve as a national technical assistance provider on the housing protections under the Violence Against Women Act. I'll turn it back over to you, Shenna.
Thanks, Natalie. If we can go to the next slide, please. All right. So as we opened up earlier, you saw that today's webinar is focused on rural housing options for survivors. And we know that when working with survivors from rural communities, there are a number of dynamics that survivors face in accessing housing in these communities. There are often smaller community networks. Rural communities often have smaller population sizes, location challenges that impact access to resources and economic thriving, such as limited job opportunities or options, lower wage earning opportunities, things of this nature. There may also be lower housing inventories when we talk about rural communities. Affordable housing inventories can very often be limited. community transitions or gentrification dynamics have a significant impact on the housing that is available in these communities sometimes, as well as there can be challenges around limited landlords. So we know in very small communities, often the same landlord can own multiple properties that are in the area. And then that in and of itself can often come with various dynamics of racism and oppression and discrimination against survivors, labeling them because of the violence that they have experienced. As advocates, I'm sure that many of you all are aware of the transportation challenges that are often present in rural communities. Regional systems may not adequately meet the needs of survivors, and then public transportation may be non-existent at all in these communities. And then there are economic opportunities, again, looking at, the dynamics of there not being well-paying jobs, thus forcing folks to seek employment opportunities in neighboring communities that may be larger, further away from the community that they are living in. And then sometimes in these rural communities, particularly when survivors have had to relocate to smaller communities, we know that the service systems can often be strained. Again, they may be located miles away in another county. When we think about hospitals or some of the service supports being in neighboring counties, and then just the overall limitations of those services sometimes, thinking about limitations on the availability of housing vouchers, again, access to food systems, things of that nature, food deserts. So these are all of the various dynamics and considerations that survivors are sometimes faced with when we talk about them seeking out housing and support and sustainability in rural communities. So if we could go to the next slide, please. So given all of these various dynamics, and I'm sure you all are aware of other challenges that survivors face, particularly in accessing housing in rural communities, we wanted to provide the opportunity today to share more information about the U.S. Department of Agriculture 515 multifamily housing programs. Very often it may be the case that advocates as well as survivors may not necessarily be readily knowledgeable about these programs or these types of housing being available in their communities. So again, this is a program that is administered through the U.S. Department of Agriculture, Rural Development, Office on Rural Development. It funds multifamily housing units in rural communities. And particularly, it provides affordable housing for very low, low and moderate income families and individuals. It also provides affordable housing for elders who are 62 years or older. And then it also provides housing for people with disabilities. And so one thing that I do want to point out that is a bit of a nuance is that even though the funds, even though this program is considered to be a rural housing program, even though the funds provide multifamily housing in rural communities, it may still not be in rural communities throughout the state, as all counties in a state may not necessarily be designated as a rural community. And we'll get into how to identify these types of properties a little bit later in our presentation. But I did want to make mention of that here on the front end. If we can go to the next slide, please. So just to touch on very briefly, some of the eligibility for rural housing programs. There is a 12-month lease that renews annually. There is an annual recertification that is required. An individual must have good cause to terminate the lease, or I'm sorry, the owner must have good cause to terminate the lease or evict a tenant. And the tenant must be given notice of any violation, as well as an opportunity to be responsive to said violation that may have come up. And then the applicants or the tenants are also entitled to a grievance process to challenge any adverse action that the owner has brought, except for in the case of evictions. And with that, I will hand it over to you, Natalie, to dive into a bit further of how to look for these properties.
Thanks, Shenna. If we can go to the next slide. So when it comes to finding USDA properties, that information is available online. And part of the reason that this is important is while every community does not have a USDA 515 property, 87% of all US counties have at least one of these Section 515 properties. So on this slide, and you'll get this information after today's webinar, is the link to USDA's website where you can search for 515 properties in your state. And the website allows you to search by state, county, town, zip code, the name of the project, or if you know the name of the management company, the name of the management company. In addition to the website, there are other ways that you may be able to identify whether a property in your community is a Section 515 property. In some cases, if the renter has a written lease, the lease might indicate that this is a 515 property or a USDA property. Another way that will give you a hint that this might be a USDA 515 property is based on the amount of rent that's paid. If the renter is paying below market rent and they don't have any sort of HUD or other local subsidy, that might be an indication that the property is a 515 property. And another way to find out is if you have a relationship with the property manager, you can just ask them and they'll let you know. Next slide. Now, I mentioned that one way that you can determine that someone may be in a 515 property is by the amount of rent that they're paying. So one thing, though, to keep in mind is that the Section 515 rents are a little bit confusing. And so I'm going to talk about the types of rents that you might hear someone mention or that might be in someone's lease that will indicate that it's a 515 property. But I'm not expecting you to remember this distinction. The takeaway here is just that these are other ways that might indicate that this is a 515 property. So for the 515 rents, the first type of rent is note rent. So if you see that phrase, then we're probably dealing with a 515 project. And what that means is that that's the rent amount that's set based on a calculation that would cover the expenses for the property, for the property's approved budget and the required loan payment that's contained in the promissory note that's signed for the 515 property. So USDA makes a loan to the property, and there will be a promissory note reflecting that. Another phrase you may see is the basic rent. And the basic rent is essentially the note rent, but it's been reduced because the property has an interest credit agreement. And what the interest credit agreement is that's an additional subsidy that's provided by USDA, and it reduces the mortgage interest rate on the property to an effective 1%, which then results in rent that's even lower than the note rent. And then Section 515 properties may also have funding from other federal housing programs. So the Department of Housing and Urban Development provides a number of federal housing programs and subsidies. One of those is the project-based rent, and what that means is that HUD is providing an additional subsidy on that 515 property in the form of rental assistance that stays with the building. And then the last type of rent that you might see is the low-income housing tax credit rent. So the low-income housing tax credit program, or LIHTC for short, is it's the main program that's used to build new affordable housing. It's also used to rehabilitate older affordable housing. So sometimes if the LIHTC program is used, then there will be additional rents that are based on the area median income. So unlike the HUD program or the USDA programs, which are set rents based on a tenant's income, the tax credit program does not necessarily have that requirement. So as I mentioned, a lot of kind of different rent forms that you might see, all of these might be indicating that this is a 515 property. Let me go to the next slide. So I just want to provide a little bit more information on the rent calculations in the USDA properties. And so when it comes to rents for USDA in the 515 program, the tenant is going to pay the higher of the basic rent, which is the market rent, or 30% of income up to that basic rent amount. So, and here's what I was talking about, where it's going to be based on their income, and why we say this is a housing program that can serve from extremely low income families to moderate income families, because their income, their rent amount is going to be set based on their income. But there is a cap in terms of how high that rent amount is going to go. So in addition to the programs that I just talked about, USDA has its own rental assistance program to further reduce tenants' rent burden. And the rental assistance program is only is not eligible at all properties, and it's not eligible for all units. But for renters who are receiving the USDA, or what we also call rural development or RD's rental assistance, they pay 30% of their adjusted income or 10% of the gross rent for the unit, or if they are participating in a welfare rent program, they will pay, their rent will be calculated based on one of those three options, and they're going to pay the higher of the three. And then the last kind of point that I want to make about these rent calculations for the USDA properties is that in addition to having a cap on what the rent amount can be, the Section 515 program provides for a utility allowance in the event that the tenant is paying some or all of the utility costs themselves. So in that case, the owner of the property is going to establish a utility allowance, and USDA has a form that they complete to determine what that amount is going to be. It has to be a reasonable amount, and the utility allowance amount is going to be reviewed annually and adjusted when necessary, but that adjustment only happens on an annual basis. And with that, we can go to the next slide. So I mentioned earlier that we provide technical assistance around the Violence Against Women Act. And so one thing to note here is that for USDA's housing programs, USDA has created a guide that can be found online that is called the Guide for Administering and Complying with the Violence Against Women Reauthorization Act of 2013 in their multifamily housing programs. So you'll note I said 2013. As many of you are probably aware, VAWA was reauthorized in 2022. And so USDA is currently working on updating their guidance to incorporate some of the changes from VAWA 2022, which we will talk about a little bit later. And one reason that we are focusing today on the 515 housing program is that that is the largest multifamily housing direct loan program that's administered by USDA. And so that is the primary way that they are providing housing in rural communities. And so, but it's worth noting there are other USDA housing programs that we're not going to talk about today that may be in your community that you should be aware of. So one of those is in addition to the 515 program, there's the farm labor housing program. There is the Section 533, which is a preservation program, and the Section 538 guaranteed loan program, where USDA makes loans or guarantees loans that are made by lenders to build rural housing. And then in addition to the multifamily housing program, USDA also administers a voucher program, the Rural Development or RD voucher program. Now, that program is very different than other voucher programs that you may be familiar with, for example, those administered by HUD, because the RD voucher program is limited to people who are currently living in USDA 515 or farm labor housing, and that housing is going to be what we call exiting the program. So either because the loan matured, or the owner has paid off their loan early, or because of foreclosure. So it's not a program where you can send people to apply, but it is covered under VAWA. So we did want to include that in today's presentation. And then one change from VAWA 2022 that is important to note is that in terms of the, I should also note that the RD voucher program is newly covered under the VAWA 2022 reauthorization. So the existing USDA guide does not address the voucher program. And another change from the 2022 reauthorization is that in the event that USDA creates any additional housing programs, they can designate those programs to be covered under VAWA. Next slide, please. And so with that overview of the 515 program, we're going to move into talking about the Violence Against Women Act. And for some people, this might be a refresher. And for those of you who are not aware of some of the changes with the 2022 reauthorization, we're going to flag those for you today as well. So in general, with regard to the housing provisions under VAWA, there are 4 categories of survivors that are protected. Those are survivors of domestic violence, sexual assault, dating violence, and stalking. We have also noted that survivors who have experienced human trafficking are protected under VAWA, and the reason for that is that they are generally going to be covered under one of these other 4 categories. So even though you will not explicitly see human trafficking survivors in the VAWA statute, you should know that they are generally going to be covered. Next slide, please. And when it comes to the housing protections under VAWA, the main protections are that a survivor cannot be denied admission because of violence that's been committed against them. So if they apply to one of the USDA housing programs, that cannot be held against them. If they're an existing renter in a USDA housing program, they cannot be evicted or have their assistance terminated because of the violence that's been committed against them. In addition, VAWA requires that the notice of housing rights be provided to applicants and tenants at certain, what we call critical junctures in the housing process. The first is where if someone has applied for housing and is denied, they should receive the VAWA notice of housing rights. The second critical stage is at the time of admission. So anyone who's admitted to USDA housing should get that VAWA notice of housing rights. And, you know, part of the rationale behind that is that someone may not be covered under VAWA at the time that they are admitted, but they may experience violence during their tenancy. And so it's important that people know about those rights. And then the third critical juncture is at the time of receiving any notice of eviction or termination. In addition to receiving the notice of housing rights, survivors can request that an abuser be removed from the lease and the housing, depending on if that's applicable. So obviously, if it's a situation where the abuser does not live in the house with them, then that's not a right that they're going to need to exercise. And then the other important right under VAWA is that a survivor has to be given time to establish eligibility for the housing program. And so, for example, one of the scenarios that we see is that abusers may not add a survivor to the lease as part of their control and abusive behavior. And so even though the survivor is living there, if they're not on the lease, generally speaking, they're not going to have a right to that unit. However, VAWA says that they must be given time to establish their eligibility to be able to remain in the unit or participate in the program. Next slide, please. Another important protection that VAWA provides is confidentiality. And what I mean by that is that any information that's submitted by a survivor under VAWA must be maintained in strict confidence. So that means housing providers can't allow anyone who's administering assistance or employees to have access to that confidential information unless they are explicitly authorized. Another important point about this confidentiality protection is that confidential information should not be entered into any shared database or disclosed to others except if the disclosure is requested or consented to in writing by the survivor, with time limits on that release of information, or if that confidential information is required for the use in an eviction or termination hearing. And the other exception is where the disclosure is required by law. But we know this confidentiality provision is key to protecting survivors and for them to be able to exercise their rights, their housing rights under VAWA. And then the VAWA guide that RD put together that I referenced earlier, it has a number of examples of best practices. And so this is not a complete list, but this is also a place where advocates really have an opportunity to make sure that USDA housing providers in their communities are complying with and operating their programs in a way that furthers survivors' rights under VAWA. And we'll go to the next slide. And I will turn it back over to Shenna.
Thanks, Natalie. This is Shenna speaking, everyone. I'm going to pause us for just a moment. It looks like there have been a couple of questions to come up in the Q&A. And I also just want to note that we will be holding office hours in a few weeks to dive into any specific questions that may come up for you either during the webinar or after you've had a chance to process some of the information. So an invitation will go out to all of the registered participants for those office hours. So one of the questions that has come up is a Social Security number required to be eligible for 515 or other USD housing programs? And I think I'll pitch that over to you, Natalie.
Sure. So the 515 program does not have any eligible immigration status requirements. So what that means is that there is no reason for a property manager or an owner for the 515 program to be screening anyone for their Social Security number. And if that's happening, applicants are free not to provide that information. The only exception to that is I mentioned that there is an additional subsidy that is available sometimes at 515 properties called the Rental Assistance Program. And the program it's under Section 521. So for renters who are applying for that rental assistance, there are eligible immigration status requirements for that program. However, if someone is part of a mixed status family, and there are members of the household who have that qualifying immigration status, those members can apply for that rental assistance without the household member who does not have eligible immigration status. And so so it does not have to, in other words, it doesn't have to be the head of household. There could be, eligible children in the household. And so those folks can apply. And the person who, for example, doesn't have a social security number is not required to apply and not required to provide that information. And generally speaking, should not be providing any, false information about a social security number. So hopefully that answers that question.
And then one more that seems like it may be in somewhat of the same alignment or spirit is around with human trafficking. Does this cover the newcomer population? Are they covered under VAWA?
I'm not sure that I quite understand the question. So if someone, if the question is, are folks who have experienced human trafficking covered under VAWA? If they have experienced domestic violence, sexual assault, stalking, then they would be covered under VAWA in terms of housing protections and their ability to apply for USDA housing, as well as to, if they were being trafficked and living in USDA housing, to be able to have the opportunity to establish eligibility for that housing.
So hopefully that answers that question as well. And just know that we are capturing your questions that you are putting in the Q&A so that we can provide some follow-up response if we don't get to those things on the webinar today, as well as I mentioned previously, we'll be holding office hours to get a little more in depth around some of the questions that maybe came up during the session. So far, a good bit of information has been shared or introduced. And so now we want to provide a little bit of an opportunity to apply some of what has been shared. And so I want to invite participants, all of you all, to participate in the chat in looking at our scenario that we have here. So I'll read this one off. It's around proving violence. Sam applies to live in a 515 property. The owner denies the application because she has prior evictions and 2 arrests in the last 12 months. Sam calls the owner and explains all of these are a result of the domestic violence in the relationship that she just left. The owner tells her he won't reconsider because he knows that she will get back together with the ex-partner. And you recall earlier, we talked about some of those dynamics that can occur for survivors, particularly in how they can be harmful in rural communities when there are limited landlords, this stigmatizing of survivors, this labeling of survivors. So our first question is, does VAWA apply? And I want to invite you to participate in the chat around that question. I see some yeses coming in. Absolutely, absolutely correct. VAWA does apply in the scenario, as you all have heard throughout the presentation in regards to some of the information that was provided. Can the owner deny Sam's admission due to her prior evictions or criminal history? Again, wanting to invite you all to participate in the chat. See some responses coming in. Maybe a little bit trickier on this one, but no, the owner cannot deny Sam's admission to the housing program because of the prior evictions or her criminal history, because they are directly related to her prior experience of violence. And based off of what you've heard, off of just your own expertise, what kinds of advocacy would be helpful with this landlord? If folks want to pop anything in the chat around that. Okay. Again, want to offer space for if there are any thoughts on what kinds of advocacy would be helpful. Training on VAWA occupancy rights, absolutely. Supplying the landlord with information on VAWA, yes. Yes. Sharing with the landlord if they will talk to you, yes, yes. So that you all are spot on. You know, the advocacy and information on VAWA rights, as well as any support on the use of self-petition or other forms of documentation in order to prove the violence. So again, just noting that Sam's use of documentation would support the demonstration that the prior things that were mentioned were directly related to the domestic violence that she experienced. And we'll talk a bit more about documentation here in a moment. So can we go to the next slide, please? So again, just now going into a little bit more conversation around proving violence. In Sam's case, the proof of violence could play out in a couple of different ways, as we talked about. The landlord could take Sam's word about the violence or ask that Sam prove the violence through the use of some type of documentation, as we were just talking about. If the landlord were to ask Sam to prove the violence, the landlord would need to make this request in writing. And then from there, Sam would have 14 business days from the landlord's request to provide the proof. If an extension would be needed by Sam, then the landlord is free to grant that extension if time is indeed, more time is indeed needed. So this is another place where, when we were just talking about the advocacy that is needed, this is where landlord engagement with advocates and domestic and sexual violence programs can be essential, because it's that relationship building that can contribute to a landlord being flexible when these situations arrive, and having kind of that better foundational understanding of the dynamics of domestic and sexual violence. I saw that someone mentioned, like, if the landlord will talk to the advocate, that, you know, that is one of the ways to get that buy-in to talk, is through that landlord engagement, and thus leading to the flexibility in proving violence. Next slide, please. So let's talk about some of the types of documentation that Sam could have provided in that scenario if the landlord requests documentation. So some of the documentation that could be provided are the VAWA self-certification form, if the survivor had it available and had chosen to engage with the criminal justice system, law enforcement, a police or court or administrative record could be provided. They could also provide a statement from a third party, or a statement from a housing provider, a domestic or sexual violence program, some type of other evidence that they may be comfortable presenting to the landlord. Next slide, please. And you heard me just mention that it's a type of documentation that the survivor may be comfortable with providing, because they get to choose the documentation type that is provided. The housing provider must accept whatever documentation the survivor does provide. And the only exception to that is when there is some type of conflicting evidence that in that case, the housing can ask for some type of third-party documentation. So next slide, please. Okay. So now that we have talked about the types of documentation, let's look at a scenario that is dealing with relocation. So Robin lives in a rural community of 5,000 residents. She has notified that her former partner, incarcerated for using violence against her, is being released in the next 30 days. She requests an emergency transfer and submits documentation to her landlord that if she remains in the current housing, there's a threat of future harm. She'd like to move to a neighboring property 2 counties away to ensure her location remains confidential and that she is safe. There is currently a 2-month waiting list at the property. Again, I want to invite you to participate in the chat. Can Robin's external transfer request be honored? Yes, absolutely, it should be. And the answer is yes. She has submitted the information needed that demonstrates her risk for future harm if she were to remain in the current housing and is covered under VAWA to do so. Next question, can Robin's request be prioritized at the property? Excuse me. Yes, she can receive priority placement in an available unit or be put on a waiting list over the other applicants in her income group. And Natalie, I don't know if you want to provide a little more context around that, that would be helpful.
Sure. So for USDA housing, the wait lists are organized by income group. So what that means is the wait list is maintained separately for people who are extremely low income. So that's 30% of area median income or less versus people who are low income. So that's between 31 to 50% of area median income, and then for extremely low income, and moderate income is above that. So the wait lists are maintained. So there are separate wait lists by income category. And so what that priority does, it puts the person at the top of the wait list for their income category.
Thank you for providing that, Natalie, because I know it can get a little tricky sometimes when we hear that, you know, folks can be put over other applicants. There are sometimes where, you know, that can get tricky, especially when you may be trying to explain this to a landlord in your community or things of that nature.
And if they're, I'll just add, you know, they can have a preference for survivors so that they are at the top of the waiting list period, regardless of income category. So that's kind of an opportunity for advocacy if you're working with local housing providers.
Thank you. And then finally, can moving assistance be covered for this survivor? What do you all think? Would moving assistance be covered or available? Correct. I see some yeses coming in. This is an allowable expense and should be addressed in an emergency transfer plan. So next slide. So essentially, you can see in that scenario, what we were kind of centering was a survivor's experience in using an emergency transfer request. So all 515 borrowers, persons owning the multifamily unit, must have an emergency transfer plan that would allow a tenant to transfer to another unit that is safe as it is defined by the tenant. So the survivor themselves, as they would define to be a safe location. The tenant would get to choose the type of transfer, not the owner or the person who is the landlord / borrower. And this transfer could be internal or a transfer to another unit, and that person not be treated as a new applicant, or it can be an external transfer, which essentially would be a transfer to a new property, and then the survivor would be treated as a new applicant. And in doing so, I just want to lift up that the same documentation requirements that we previously discussed would be applicable to a person requesting an emergency transfer. There would not be any new documentation requirements that would be required. Next slide, please. And so to be eligible for the transfer, again, the tenant must, the tenant must request the transfer, and the tenant has reasonable belief of a threat with imminent harm from future violence if they were to remain in the same assisted housing unit. So that person believes they would be at risk of harm if they were to remain housed in that unit, or if the tenant is a victim of sexual assault and the sexual assault has occurred on the premises during the 90-day period preceding the request for them to transfer. Pause there to see if there are any questions. Okay. And I think with that, I will turn it back. Oh, there is a question. So I do see a question that came into the chat. How often within a transfer period can a transfer be done if danger arises again, say within a year or so? And Natalie, I'll pitch that over to you to dive into the weeds a bit.
So there's not a limit on the number of transfers that can be requested. The language around transfers is it's about a survivor's safety. And so if they have requested a transfer, that transfer has occurred, and then there is some other incident that happens, whether it involves the same party or a different party, and they need to request another transfer, there's not a limit on the number of transfers that can be requested.
And so I'll just note that as you are learning more about this type of housing programming that survivors have access to, I want to just, lift up again that that question again speaks to the importance of that landlord engagement and being able to build relationships with landlords, because we often know that those types of questions do often come up when a survivor may be seeking to relocate, their housing due to the violence that they have experienced. It may be the case that a landlord does say, well, how many times does this person get to transfer to one of my properties? And those are very real, things that we know you all experience as advocates. But kind of leaning in on leaning towards what Natalie just shared, is there is not a specific number of times that the request can be made. Next slide, please. And I think this goes back to you, Natalie.
Thanks, Shenna. So we have another scenario where we're going to ask you to respond in the chat. For this one, Lonnie and Luke have lived together for years. The past 6 months, Lonnie's violence toward Luke has escalated, and Luke has requested to bifurcate their shared lease. The violence has caused Luke to lose his job, limited his financial resources and support networks. So the first question is, what are the landlord's responsibilities to each tenant?
And feel free to just drop your responses in the chat.
All right, looks like I might have stopped people with this one. All right, we've got one response here is that Lonnie needs to go. I love that, short and to the point. So that gets to the second question on the slide, which is which tenant should be required to move, and that's absolutely true. It's going to be Lonnie, who's the harm doer in this scenario. All right, other responses are coming in. If one is a victim of violence, he should honor the response, possibly find housing that Luke can afford if he has a unit that is available. Oh, correction. Okay, if one is a victim of violence, he should honor the request. So, just in terms of, there's a few things highlighted by this scenario. So one thing is that even though, it's called the Violence Against Women Act, and that can be confusing, the protections are not limited based on someone's gender identity or sexual orientation. These protections are available to anybody. And so the fact that in this scenario, it does not sound like there is any dispute about who is the harm doer. So the landlord should be providing VAWA notices at this point. They should remove Lonnie from the lease and the unit. As we talked about, they'll most likely have to go through the eviction process that's required by federal, state, or local laws. And in this case, we know that they are both on the lease, but I think the scenario is getting at that Lonnie is the head of household and the person who has established eligibility under the program. And so if Luke has not established eligibility for the housing, then the landlord has to provide him time to establish his eligibility. If Luke has already established his eligibility for this housing, then Luke is the one who gets to remain. And if it turns out Luke had not previously established eligibility and he is in fact not eligible for the housing, then Luke would have to be given time to find alternative housing. Now, you know, as we mentioned before, in terms of the eligibility, in this scenario, because Luke is not working, probably not going to have an issue with income eligibility, because it's going to be low income. One issue that we do see in the 515 portfolio, particularly where there is not rental assistance available, is if someone has no income coming in, they will have a hard time qualifying for the unit because there is going to essentially be whatever the basic rent is for that apartment. So they're going to have some income. But this is a place where, you know, advocacy is important, especially if there are victim compensation funds, rental assistance programs, or other things like that, that can provide a bridge, an income bridge, while Luke is trying to secure housing. All right, it looks like the chat is on fire while I've been talking. So let's see here.
Mrs. Shenna speaking. It looks like there have been some points made about perhaps Luke would want to start over fresh altogether, which is absolutely true. We know that survivors often may want to relocate and begin anew. And then I think there was, let me see. Oh, yes, another very good point about if Luke did leave, then that could offer additional protections, because then Lonnie would not know where Luke relocated to. So yes. And are there other things that you are seeing, Natalie, to lift up?
I think one important point that all these comments raise is that even though we have these VAWA protections, they may not be helpful. And at the center of any of these decisions is really the survivor that we're serving and what they want to do. And so, as someone pointed out in the chat, even though Luke has the right to remain in the unit, perhaps in terms of what Luke wants to do is not to remain in that unit. And so, you know, this is a tool, but it doesn't mean that, you know, depending on the wishes of the survivor, like that's our starting place. And where VAWA is helpful, we should use it. And where it's not, then just don't. All right, so let's move on to the next slide and talk about lease bifurcations. So what do we mean by that? That refers to the process where and I use the word borrower because that's USDA's language around, they call their owners or landlords borrowers. But they can bifurcate or split the lease so that they can evict the abuser while allowing the survivor to stay. So in our last example, if Luke wanted to stay and wanted Lonnie removed from the unit, then the landlord not only has that ability to do that, but has an obligation to do that under VAWA. So if the person who is evicted is the only tenant that's eligible to receive the housing assistance, then the landlord has to provide the remaining tenant 90 days or until lease expiration to be able to move or establish eligibility for another covered housing program. And as we noted on the slide, that 90-day period or lease expiration period, there is the potential to ask for a 60-day extension because of the realities of trying to find alternative housing. importantly, the landlord has to follow whatever the federal, state, or local laws are with regard to evicting the abuser. I see a question here about if both parties are filing VAWA claims. So if that is the case, that is the one exception under the documentation requirement that Shenna touched on, where the landlord can ask both parties to provide documentation to be able to determine who is entitled to the protections under VAWA. Shenna, I don't know if you want to say anything more about that.
No, I was just going to put in the chat exactly what you said. This is one of those times where, you know, there may be conflicting evidence that arises. And so exactly what you just said.
All right. Let's go to the next slide. So while we have really tried to focus on the USDA housing programs, we are going to touch on HUD's Housing Choice Voucher Program as if, you know, to make things a little bit more confusing. But there are a number of reasons for that. One of those reasons is that more than 20,000 tenants that are living in 515 housing have a HUD Housing Choice Voucher. And this goes back to you know, kind of the earlier points I was making about there are different amounts of rent that may be charged in the 515 property. And in some cases, because the rent is set at the amount that is the highest, that is higher of 30% of income or up to market rent or market rent, you may have tenants that are paying more than 30% of their income towards rent. And so they are rent overburdened. So one way to address that is for folks to apply or who have housing choice vouchers are able to move into the 515 housing. So they're able to use those vouchers. Also, survivors. So if you have a 515 resident who is receiving a HUD housing choice voucher, they can move with continued assistance using that voucher. And so one of the key components of the HUD voucher program is its portability. So someone with a voucher could move. In addition, the Section 8 Housing Choice Voucher can be used as an emergency transfer option. This is especially true in cases if there is a housing authority in the jurisdiction that has housing choice vouchers that are set aside for that purpose. Also important to know is that when we're talking about the VAWA obligations and you're dealing with someone that has the HUD voucher, the housing authority or PHA is the housing provider that's responsible for complying with the VAWA emergency transfer provisions for that voucher holder. And then in the event of family breakup, for someone that has a voucher, the housing authority has to ensure that the survivor maintains the assistance. And in some cases, if they have additional vouchers, they may just issue another voucher to ensure, particularly if the survivor was not the head of the voucher holder. But if that's not the case, the survivor should be the one that ends up with the voucher at the end. All right, let's go to the next slide.
This is Shenna speaking really quickly. Natalie, I don't know if you saw the one question in the chat and it's asking if PHAs, public housing authorities, do they automatically have these vouchers? I'm assuming that the questions is if they automatically have the housing vouchers.
Thanks for flagging that, Shenna. So in terms of the different the vouchers that exist, so they're in the traditional housing choice voucher program, they're not necessarily vouchers that are set aside for survivors, unless the PHA has opted to do that in part of their priorities around the Section 8 administrative plan. However, from time to time, there are a number of special vouchers that are created and administered through HUD. So for example, the name of the voucher is escaping me at the moment, but there was during the pandemic, a pot of vouchers that were made available to housing authorities that could be used for survivors who were covered under VAWA. And so in order to find out that information, you just need to contact your local housing authority. And if they don't have any preferences for survivors, that is an opportunity to advocate for those preferences, so that when additional vouchers become available, they can be used for folks that are trying to transfer in the event of an emergency. And then this other question, so vouchers are issued to a specific individual. And so while they may benefit a family, there is a head of household who is the voucher holder. So thank you for that question. So I could clarify that. Okay, let's get to our VAWA 2022 updates that I promised that we would provide. So in addition so I mentioned that there were some new USDA covered housing programs. There were some additional covered housing programs, and the catch-all provision applied not only to USDA, but to any of the federal agencies with housing programs. And so there also was the 2022 reauthorization included updated definition of domestic violence. So HUD noted that it's interpreting its existing regulations that define domestic violence to address the evolving way that people cause harm through domestic violence, including as a result of economic abuse and technological abuse. Another important update is that it added a protection from retaliation, intimidation, or interference. And what that means is that now tenants and program participants who exercise their rights or participate in any process related to VAWA housing protections cannot then be evicted or retaliated or intimidated as a result of exercising those rights. So that was not explicit. Well, people had been arguing it. It wasn't explicitly in the earlier versions of VAWA, and so now it is explicitly clear that that is protected activity. Another important development in 2022 is the creation of a complaint process for the enforcement of VAWA violations. So HUD has their Fair Housing office has created a complaint process that extends to all covered survivors under VAWA covered housing programs. And all right, two more I'm going to touch on. The right to report crime, which is contained in section 603. And what that does is, you know, we've talked about the categories of folks that are protected by VAWA. This section applies to anybody. So regardless of whether or not they are the survivor. So that would mean it applies to other household members, the landlord. And the reason for that is what this provision does is it supports the right of anyone to seek law enforcement or emergency assistance. And so one of the problems that many folks on the ground were reporting was lease provisions, local ordinances, or other laws that prohibited survivors or penalized survivors for seeking emergency assistance. So calling 911 for police, for medical assistance. And so this provision prohibits any nuisance laws or crime-free housing policies that impose penalties on people. So either the tenant or their landlord for calling the police too many times within a given period. And then last, 2022 provides additional training and technical assistance so that VAWA can be implemented widely, and to provide training to funding for technical assistance providers to provide what we know is important training around VAWA. And we can go to the next slide. So specific to USDA, so, you know, I mentioned this VAWA complaint process. USDA also has a complaint process, and their complaint process is not limited to VAWA. And so you may be working with survivors who are having issues with their landlords in the 515 program, where it has not risen to the level of an eviction. And so it's important to know that in addition to the VAWA complaint process, there are other processes short of going to court where they can raise those issues with their housing provider. And so the grievance process allows both applicants, so someone who applied, let's say applied for USDA housing and was denied, or for existing tenants to challenge an adverse action by their landlord or a landlord's failure to act. And so what this looks like is, it is essentially an informal meeting with the owner. And if the issue is not resolved in that informal meeting, then the renter can request a more formal hearing before a hearing officer. Another complaint process is the Fair Housing complaint process. So the Fair Housing Act, it protects all individuals from housing discrimination. So where VAWA is limited to federally funded programs and housing, the Fair Housing Act is not limited in that way. And so it might provide broader relief, particularly if you're working with a survivor and they may have, they may have been coming from some other housing situation where they were experiencing problems. And so under the Fair Housing Act, while survivors are not specifically named, because the vast majority of survivors are female, discrimination against survivors of violence can constitute sex discrimination. And so if folks are experiencing what looks like housing discrimination, that's another complaint process. And then the VAWA complaint process, which we have already touched on. And I think that's all I have for this slide. So if we can go to the next slide, I think we are ready to move into questions.
Yes, it looks like we have about 5 minutes left for questions. This is Shenna speaking. And I know that a number of questions have come through both in the chat as well as in the Q&A platform. So let's see. And again, I do want to remind everyone that we have collected these questions and we'll touch on them in the office hours that will circulate some information for. And maybe we can put our heads together as well, Natalie, to see if we can send out some type of kind of written FAQ or of some sorts based off of questions that have come up today. Not to put more work on your plate, but we can put our heads together and see how that could look. Yes, this will be available to view later. It is being recorded, and the information that was shared during the presentation will also be sent out and shared with everyone. So since we are limited on time, I'm going to go ahead and advance us to the next slide, please. Because again, we will honor answering those questions and some follow-up activities. So Natalie, do you want to share a little bit more about the resources noted on the NHLP slide here?
Yes, thanks, Shenna. So we have a website at nhlp.org/OVW grantees, where we maintain a number of resources about the Violence Against Women Act. I know I also touched on a number of federal housing programs. So we have resources on the various housing programs as well. And we just released an updated state and local law compendium, which is available on our website. And that compendium talks about the housing rights of domestic violence and sexual assault survivors across the 50 states. And so if you have questions like who pays, does the landlord have to change the locks? That's a common question that varies from jurisdiction to jurisdiction. So other types of questions, or you're engaged in legislative advocacy and you're looking for some policy examples. And then, as I mentioned earlier, we are technical assistance providers. And so you have issues or questions that come up, we are happy to field those and help you try to find an answer to them. And so you can contact me by email, and I've also included my colleague who works on our survivor housing project with me, Kate Walt. So my email is nmaxwell@nhlp.org, and that's also going to be in the slides. And I think we can go to the next one. Thanks. I'll turn it back over to Shenna.
Thanks, Natalie. This is Shenna speaking. And then just to note, the safehousingpartnerships.org website, that is a site where a number of the technical assistance partners who are a part of the Safe Housing Partnerships Technical Assistance Consortium have housed resources on this website. And so you can find various different topics by accessing the site here, safehousingpartnerships.org. And then if you'll go to the next slide, please. And then also you can feel free to reach out to us directly using any of the various ways to get in contact that are noted here on this slide. I can also pop my email into the chat, and just as Natalie spoke, NRCDV is a technical assistance provider as well and is happy to follow up with you all and provide further technical assistance around these matters. In collaboration always, I'm happy to do so with our partners at NHLP. So this just notes how we were able to bring you all this information today. Always want to acknowledge the resources that support our ability to bring insightful information forward. Next slide, please. And just want to extend our gratitude to you all for joining us today. We hope that you have gained some new information by joining us today. We hope that you have more curiosity and will join us for those office hours once we circulate the announcement. You can scan the QR code here and provide feedback to us. That's always welcomed and appreciated. And again, just thank you all for joining us today. Have a great rest of your week, everyone.